Hi, good morning to everyone. Welcome to Vako Legal channel. This channel is basically a host of labor law trainings programs, which are starting this week onwards, live on YouTube and other channels, especially LinkedIn and Google Meet. There are scheduled programs which will be launched soon across to the interested people. They can subscribe to these programs with a very nominal fees. And there are certain programs which are available on free on the same channel on the YouTube recorded. They can take the benefit from these programs. I'm beginning with the first chapter of New Labor Code, especially Code on Wages 2019. I may talk about rules, acts, and policy, and then move on to various aspects of audits and compliance checklist, and our as an law consultant, our legal advisory to the organizations on restructuring of wages and certain maintenance of records. For our reach out, we have provided our details for your call and your discussion and your any service which you may seek from us. Let me begin with. So I may talk about the Code on Wages rules and acts existing, where four old act has been subsumed into the same Code on Wages. Now I may further go on to the applicability of this code. This code is applicable to all establishment, factories, and shops, and the provision of this code apply to all employees irrespective of their category and status. Please understand that word very carefully. All category and status. I know these acts are basically the provision in such manner. Even if an employer has one or more employee, all provision of these codes will apply to such an employer, unlike existing law. Earlier, these law basically you see that are being explained in such manner where applicability is on different foots. For example, Payment of Bonus Act is applicable to establishment employing 20 or more employees, and Payment of Wages Act covers those employees drawing less than 24,000 per month. Mini Wages Act applying to the workmen of scheduled employment only. This was the scenario in the existing law, but with the upcoming new wage codes, which is already implemented into the environment, into the industry across, with this code, the employee limit of applicability is removed. Henceforth, mini wages are applicable to everybody, every class and sections and category of employee, even including their status. Limit of wages up to 24,000 per month in case of claiming illegal deductions or delay in wages is no longer. So even the limit of deduction, sometimes the wages are being deducted from the employee salary was earlier. There is a limit up to 24,000, so they can contest their matter in the court, in the labor department through the third-party interventions, and can claim their benefits of deductions. But now this benefit is available to all class of employee. All employee, including supervisor and manager, can now seek protections against illegal deductions and or delay in their wages payment against the employer. Scenario is that as per new wage code, the duration has been reduced from earlier existing period. Now it is fixed to 2 days, within 2 working days, whereas numerous employers are not ordered to pay their dues in that particular time. They take time in calculating those full and final dues. Now it has to be all class of employee can contest and demand these benefits within 2 working days. Chapter 1 basically talk about the title, extent, and commencement, and then we may move on to the definitions from A to Z clause under section 2. Definitely it will give you more idea, because this is very important to understand before we may start to any other understanding of the law. Then prohibition of discrimination on a ground of gender, that section 3 we may give some idea that how it will be moving. Discuss then decision as to dispute with regard to the same and similar nature of work. Let me see in the first training session, I may talk about to the lesser area, and that would be only including definitions and expansion of title, or the comments and extent of title. So Code on Wages 2019 section 2 from A to Z. The code provides 26 definition of term drawn from 4 existing law. It has some definition with key changes. I may highlight those key changes in a very quick manner for your grasping those changes in a very quickly manner. Now, contract labor has been defined as a worker who is employed. Now, earlier contract labor was not in the not defined into the worker category. Now it is defined into worker category, and apprentice included in the definition of workman, whereas in the code it is excluded. Okay, now apprentice is excluded from the workman category. Even the new wage code, minimum wages, stock of employee limited only to the scheduled employment included out worker. So जो पहले मिनिमम वेजेस थी वो एक लिमिटेड एंड शेड्यूल एम्प्लॉयमेंट में थी. नाउ इट हैज बीन आउट क्लास to out all class of worker. Definition of worker in code exclude apprentice under the Apprentice Act and person employed in supervisory capacity drawing wages exceeding 15,000 per month and who are employed mainly in the managerial and administrative category. So definition of worker in code exclude apprentice. Definitely I have already talked. And the person employed in supervisory capacity drawing wages above 15,000 per month who are employed mainly in the managerial and administrative capacity. They are also taken out from the worker category. Working journalist and sale promotion employees are included in the definition of worker. So please be careful here. I am talking about this category, especially this category. They are being introduced here and to be read as the class of worker. You can see here this I am talking about working journalist and sale promotion employee are included in this category. Okay, so you have to be very, very cautious in order to understand these aspects. I am thoroughly understanding that you can understand these aspects. Okay, so you can take a look of especially here. Okay, now take care. Now let me move on to the another level definition. So definition of contract labor means basically comes under section 2G. A worker who shall be deemed to be employed in or in connection with the work of an establishment when such worker is hired in or in connection with the such work by or through a contractor with or without the knowledge of the principal employer. Once again, you can understand this. Contract labor means a worker who shall be deemed to be employed in or in connection with the work of an establishment when the such worker is hired in or in connection with such work by and through a contractor with or without the knowledge of the principal employer and include the interstate migrant workman but does not include a worker other than part-time employee. So part-time employee इसमें इंक्लूड नहीं आते डेफिनेशन ऑफ वर्कमैन, डेफिनेशन ऑफ कॉन्ट्रैक्ट लेबर. कॉन्ट्रैक्ट लेबर में पार्ट टाइम एम्प्लॉय नहीं आता है. प्लीज टेक द नोट ऑफ दैट. Okay, interstate migrant workman is also to be read into the contract labor. Okay, now they basically employed by the principal in connection with the work. They are basically deployed by their contractor in the establishments. They are being hired in connection with the work through a contractor. Okay, now whether or not there is any knowledge to the principal employer in regard to the hiring of these people. Exclusively part-time employee, not to be read as in contract labor. Definition exclude the person from definition who is regularly employed by the contractor for any activity of his establishment and his employment. Now, any employee, any person who has been employed by the contractor for his own work. Now, earlier definition saying that contractor employed the person for the establishment for the purpose of in or in connection with the establishment. Okay, to the principal employer. Now, if suppose this people are being doing the work with the contractor himself for any activity of his establishment, of his employment is governed by mutually accepted employment conditions between the contractor, we call it establishment, and the contract labor and the employees. That includes engagement of permanent basis and get periodical regular increment. Now, if suppose such contract labor getting a periodical regular increment, social security coverage, any other welfare benefit in accordance with the law for the time being in force in such employment. ठीक है, यहाँ तक समझ गए हैं. Now let me move on. If there is no definition of principal employer in the code, the meaning of definition would be that only those persons would be deemed to as contract labor who are hired in connection with the work of the establishment of the principal employer. Okay, so of the establishment of the principal employer. Okay. Now, if suppose contract labor is engaged in the establishment, what does it mean? Are they engaged with the contractor? Are they engaged with the principal employer? They are engaged with the contractor because they are working of the establishment, their own establishment. But now suppose they are working of the establishment of the principal employer. In that case, do you call them contract labor or you call them employee? They are the contract labor now because they are being engaged for the work of the principal employer with, that's a establishment, no doubt about that. Now definition, employer section 12 is basically provide that a person who employs, whether directly or through any person or on his behalf or on behalf of any person, one or more employees in his establishment, including contractor or legal representative of the deceased employer. So definition of employer. So यहाँ पे employer की definition समझ लीजिए, basically person who employ, whether directly or through any person. Means मतलब contractor. Any person means contractor. Okay. Or on his behalf, or directly on behalf of any person, or किसी person के द्वारा, one or more employee in his establishment, including contractor, legal representative of the deceased employer. So contractor भी इसमें आ सकते हैं, legal representative भी आ सकते हैं deceased employer के. They all to be read as an employer, which means in respect of contract labor employed in this establishment or factory, occupier of a factory, or the person who has ultimate control over the affair of this establishment will be deemed as employer for the purpose of the provision of this code. So contract labor जो employed रहती है establishment में और factory में और occupier of a factory में or the person who has ultimate control over the affair of the establishment. So ये जो लोग हैं, ये जो the controller हैं, ये जो manager हैं, deemed to be as an employer for the purpose of provision of this code. So employer definition में ये सब लोग employer definition में आ जाते हैं, जिसमें अगर मैं बोलूँ the person who is having ultimate control over the affair of the establishment, the person who employed for the purpose of controlling this action, and who is maintaining, who is having the authority, ultimate control, affair is entrusted to a manager, okay, or its managing director, can be a contractor, he can be a legal representative of the deceased employer establishments. For the bonus purpose, the employer will be responsible for the bonus payable to the contract labor which has not yet been paid as per the definition of the Bonus Act. Now, खाली bonus purpose के लिए है, वो employer will be responsible. These people are not the responsible. Only director will be responsible, who is having ultimate control over the organization. For all other purpose, these employee, these manager, these authorities, those who are having complete control over the affair of the entrusted to the manager or managing directors or in term of any senior person to be read as an employer. Now let me talk about the definition of certain definition accounting year. This new wage code is maintaining the accounting year definitions starting from the 1st April of every year. Especially it is being an advisory board, means central advisory board or state advisory board constituted under this section. Then appropriate government, basically there are two appropriate government in this applicability of the act, is central government and state government. Say government, central government for the establishment under it authority, railway, mine, major port, banking, insurance, telecommunication, corporation set up by the central act. तो देख लीजिए, रेलवे है, माइन है, मेजर पोर्ट है, बैंकिंग है, इंश्योरेंस है, टेलीकम्युनिकेशन है, and any the corporation set up by the central act or central public sector undertaking and their subsidiary and autonomous bodies and contractor for such establishment, the state government for any other purpose. Now definition, code on wages of a company defined under section 20, section 2 of the Company Act. So need not to be much talk about. Basically it's a matter of definition of that, what do you mean by company? So company to be read as per the clause 20 section 2 of Company Act 2013. Contractor in relation to an establishment mean any person undertake to produce a given result, especially maybe other than the mere supply of goods. ठीक है, वो एक उसको परफॉर्मेंस देना होता है for the establishment through contract labor or supply contract labor as a human resource and include a subcontractor. Now section 2G contract labor, there we talk about the contractor. basically who is basically the producing, undertake to produce a given result. So contractor is nothing but is a person who undertake to produce a given result for the establishment through its contractor labor. So there is a responsibility of contractor labor in new codes. Here, the contractor cannot deny the performance with the establishment. Here, through his labor, through his human resource, including the definition of subcontractor to be read under this relation to the establishments with this person. Now, contract labor means deemed to be employed in or in connection with work of an establishment when hired through a contractor and include an interstate migrant but does not include a worker other than a part-time employee. He is regularly employed by the contractor in his own establishment with the standard employment conductor. So it do not include any employee that is employed with the contractor in his own establishment with the standard employment conditions, regularly payments, all benefit to be discharged. They are not to be read as a contract labor. They are the regular employee. Gets periodic increments, social security, welfare benefit according to the law in his employment. Now, continuing these definitions, you can see the cooperative society means anybody corporate established by or under any central or state act and does not include a company or cooperative society. Corporation में ना तो company आएगी ना cooperative society आएगी. It is different than any cooperative society or company. Direct tax means any tax chargeable under the Income Act 1961 from the company profit, tax 1964, agriculture income tax law, any other tax declared by central government by notification to be a direct tax for this code purpose. Now, employee means any person other than apprentice under the Apprentice Act, employed on wages by an establishment to do any skilled, semi-skilled, unskilled, manual, supervisory, managerial, administrative, technical, or clerical work for hire or reward, whether the term of the employment are expressed or implied, and include a person declared to be an employee by the appropriate government, but does not include any member of the armed forces of the union. So definition is very clear of the employee, basically anyone, any person who is employed on wages by an establishment, can be of any skill, whether a managerial, administrative, technical, and non-technical, clerical, work for hire or rewards, whether or the term of the employments are expressed or implied, कोई फर्क नहीं पड़ता, and include a person declared to be employed by the appropriate but does not include any armed force person of the Union of India. Now, employer means a person who employ one or more employee directly or through another person. So, employer कौन है? Who basically employ one or more employee directly or through another person, include in a factory the occupier as per Factory Act, and we are named the manager. Okay. Now, in any other establishment, the person or authority with ultimate control for the manager, managing director, entrusted with those affairs, a contractor, and a legal representative of a deceased employer. Now, continue. What do you mean by establishment? Section 2M. Any place where any industry, trade, business, or manufacturer occupier is carried on and include a government establishment. Section 2N, factory, defined under Section M of Section 2 of the Factory Act 1948. Same definition is being applicable for the factory in this act. Government establishments, any office or department of the government or a local authority. Income tax, I have already explained you as per the Income Tax Act 1961. Industrial disputes, Section 2Q. Very important, Section 2Q. Any dispute between the employer or between employer and worker, or worker and worker connected with employment or condition of labor. Any disputes between an individual worker and employer arising out of discharge, dismissal, retrenchment, or termination. Discharge, dismissal, retrenchment, and termination. So DDRT. So employer arising means a dispute arises between individual worker and employer. Dispute arises between employer or between employers and worker. तो एम्प्लॉयर का भी डिस्प्यूट हो सकता है, एम्प्लॉयर एंड वर्कर का डिस्प्यूट हो सकता है, और वर्कर का डिस्प्यूट हो सकता है. तो कितने तरह के डिस्प्यूट हुए? एम्प्लॉयर का हुआ, वर्कर और एम्प्लॉयर का हुआ, नंबर 2, वर्कर का हुआ, नंबर 3, और इंडिविजुअल और एम्प्लॉयर का हुआ. तो 4 तरह के डिस्प्यूट हो सकते हैं. So industrial dispute is covering all 4. Inspector cum facilitator means a person appointed by the appropriate government under section 51 of the new wage code. Would be read as a inspector cum facilitator. Minimum wages basically fixed under section 6 of the code of specially new wage code to be read as the minimum wages. Now the prescribed, if you see section 2U means prescribed by rules made by appropriate government in this code, and notification means any publication is published in the Gazette Center State or as applicable. Same or similar work, same work or work of similar nature means work required the same skill, effort, experience and responsibility. Skill, effort, experience and responsibility. Please take the note. Same work or work of similar nature being conducted by any employee under similar conditions where gender difference are not of practical importance of the terms and condition of employment. So gender neutrality is there in this act, where same work or work for similar nature, even the two men, those who are doing the same and similar nature of work and their experience, responsibility, skill and efforts are the same in the nature of activity, but they are supposed being paid different wages. They to be covered under this type of legislation of definition section 2B. Now state include union territory. UT will also to be read as in state, and tribunal has the same meaning as a clause or of section 2 of the Industrial Dispute Act. So tribunal जो है section clause or of section 2 of ID 1947 to be read. Now let us come to the wage definition section 2I, very important under this law. We will give a lot of emphasis in the going forward in this discussion. In the next class I may switch today maybe definition and 2 or 3 more definition across. So let me talk about section 2I, meaning all remuneration payable to person employed in connection of the employment or work done, including, okay, now basic pay, DNS allowances, retaining allowances if any, but does not include bonus. देख लीजिए आप, wages basically maintaining these 3 items. We call it basic pay, we call it DNS allowance, we call it retaining allowance. ये 3 ही हैं जो wages बनती हैं, इन्हीं को हम wage बोलते हैं, और बाकी को wage नहीं बोलते हम. Now, but does not include means what? It does not include bonus. Bonus इसमें include नहीं होता. Any part of the term of employment that then value of the house accommodations or amenity exclude by order. Employer contribution to pensions, provident fund, interest, ये भी इसमें include नहीं होता. देखिए बोनस देख लीजिए, HRA देख लीजिए, and कोई भी amenity होंगी, कोई भी contribution toward the EPF or EPS or IDLI or any type of ESIC, conveyance allowance है, ठीक है, ये भी नहीं include होता है wages में. और traveling allowance है, some paid to defray the extraordinary expenses of the employment, and house rent, HRA अगर मिलता है, remuneration payable under the award, settlement order, anything which is basically coming the later part when dispute arises during their discharge or termination process. Overtime allowances will also not be taken into the wages. Commission payable to the employee, gratuity or termination, and retrenchment compensations or other retirement benefit or ex gratia payment. Proviso, if payment under clause A to I, देख लीजिए A to I, exceed 1/2 or such other percent notified 1/2, अगर ₹1 सैलरी है और अगर ये A to I 50 पैसा हो जाता है, तो of the total remuneration the excess shall be deemed to be as an wages. और अगर ये 56 हो जाता है तो ये 6 पैसे वेज में चला जाएगा. ₹100 में से अगर 56 इधर हो जाता है and then here left 44, so this ₹6 would be read into the wages for calculation of the benefit. Why? It is for equality of wages to all gender, wages payment purpose, emolument under D, F, G, H. So देख लीजिए D, ये देख लीजिए D, F, G, H, दोनों ये, इनमें से उठा के, ठीक है, shall be taken for the computation of wages. इन चारों को उठा के आपका कंपोनेंट बना देंगे वेजेस को. कन्वेंस अलाउंस को उठा लेंगे, हाउस रेंट को उठा लेंगे, रिम्यूनरेशन पेबल अंडर रिवार्ड को उठा लेंगे, ओवर टाइम को उठा लेंगे. अब समझ लीजिए आप, अगर ये एक्सेस हुआ तब, ओके. नाउ एक्सप्लेनेशन, रिम्यूनरेशन इन काइंड गिवन इंस्टेड ऑफ ऑल और पार्ट ऑफ द वेजेस, इट शुड नॉट एक्सीड मोर देन 15%. ये 15% से ज्यादा नहीं एक्सीड होना चाहिए. अगर ये 15% से ज्यादा एक्सीड होगा तो हम इसको भी उठा के वीज में यहाँ पे डाल देंगे, यानी यहाँ पे हमें ये डल जाएगा एक्सेस में। जो इसका एक्सेस आता है वो यहाँ पे आ जाएगा, इधर यहाँ पे एक्सेस वाला, ठीक है। तो ये ध्यान देने वाली चीज है भाई। लेट अस मूव ऑन। वर्कर section 2Z, last definition of the code on wages, section 2, which will be covering our first lecture, and I'm sure you all will be benefited from this talk. Continue having this on my YouTube channel, especially you can take the note of my YouTube channel. It is Vako View. It is at Vako View. आप देख लीजिए, मेरा चैनल है Vako View. नाउ आप जाएंगे VIACO View, VIEW। आप Vako View में जाके आप अपने को सब्सक्राइब कर सकते हो, ठीक है, एट Vako View। और आप जाके मैं आपको लिंक दूंगा, उस लिंक पे जाके आप अपने को सब्सक्राइब कर सकते हैं। और ये आपने करना है 988 ओके 1633 611 एक नीचे में यहाँ पे भी देखिए 9881633611। तो ये जो एक नंबर है, इस नंबर पे आप कभी कभी रीच कर सकते हो, समझिए। नाउ वर्कर की डेफिनेशन अगर आप देखेंगे, वर्कर की डेफिनेशन में आपको ये मिल जाएगा। वर्कर की डेफिनेशन में ये सब मिल जाएंगे आपको। आप देखेंगे वर्कर की डेफिनेशन में क्या है, मीन्स एनी पर्सन एक्सेप्ट एन अप्रेंटिस अंडर द अप्रेंटिस एक्ट employed in connection to the manual, unskilled, skill, semi-skill, technical operation, clerical or supervisory work for hire or reward, journalist, okay, journalist nature of activity, okay, journalist हो सकता है और सेल प्रमोशनल वाला हो सकता है। ये भी वर्कर की डेफिनेशन में डाल दिया गया है। अप्रेंटिस को यहाँ से निकाल लिया गया है। अप्रेंटिस आर नॉट टू बी रीड एज एन वर्कर, okay, whether any nature of work. And the industrial disputes proceedings include person dismissed, discharged, retrenched, dismissed, discharged, retrenched in connection with the consequences of the disputes, but does not include army personnel, does not include police service or person officer staff, and mainly in manager administrative capacity, supervisory capacity, drawing wages more than 15,000। ये चार कंडीशन है, ये लोग वर्कर में रीड हम नहीं करेंगे। लेट अस मूव ऑन। सो यहाँ तक आज मैंने आपको बताया। अब हम आगे सेक्शन 2B ये भी कवर कर लेते हैं, एंड देन वी मूव ऑन फॉर द नेक्स्ट टॉपिक इन द नेक्स्ट क्लास। सो सेक्शन 2B, we may read it, the definition of the same work or work of similar nature taken from the Equal Remuneration Act, जो पुराना था वहां से, ओल्ड एक्ट में से इसको एक्सपेंड किया गया है न्यू वेज कोड में। नाउ एप्लीकेबल टू ऑल एम्प्लॉय रादर देन टू मैन एंड वुमेन। नाउ जो एक जेंडर था कि वुमेन शुड नॉट बी exploited under the same and similar nature of work, should not be paid the less. Now I may show you one of case in the next lecture, in the next training program. There you may benefited out of that understanding of the rules and regulations through the case law. So thank you for the program, for the hearing the first lecture. Appreciate you all to joining it at this channel. I may connect you, my link of this program will be lively available on YouTube and LinkedIn. Thank you.